Dear students, I have come with a new module, that is consideration. Now, what do you mean by consideration? Consideration, in simple terms, it is something in return. See, I work for a university. That meaning I'll get my salary. That is my consideration. So if I write a book, I'll get my royalty. It's my consideration. If I'll do a YouTube video, I will get my consideration. That is, that monetary benefit what I'm getting is the consideration. So if we talk about consideration, it is an essential element of a valid contract. We have seen that 10 essential elements are there for a valid contract. So consideration is one of the essential elements of a valid contract. So as per section 10 of the Indian Contract Act 1872, essentials of the consideration is one of the essential element of a valid contract. So that is the importance of the term consideration. Now, if you see the definition, section 2, subsection D of the Indian Contract Act 1872 defines consideration as when at the desire of the promiser. That is very important. Desire of the offerer or promiser, the promisee or any other person has done. See, promisee meaning the offeree or to whom the offer is made. They are doing something or abstain from doing something, or they are agreeing that we will not do this, or does or abstains from doing, or promises to do or abstain from doing something. Such act or abstinence or promise is called consideration for the promise. Sometimes it will be for doing something, writing a book, giving a YouTube video, giving a lecture, valuing a thesis. It can be anything, doing something. Or it can be not doing something. See, for example, a movie producing company, you will not sell this rights to somebody else. We are buying that, or patent, copyright. We are getting this exclusive right. You will not sell this right to anybody else. You will not share this trade secret with anybody else. Not doing something, that also you can get the consideration. Or it's a promise to do. You will construct a building within 1 year. You are entering into a contract. So promise to do on a future date. Now, essentials of valid consideration, again 8 points are there. We will see what are the points. So first is consideration must move at the desire of the promiser. So offerer has to consideration must move at the desire of the promiser. Offerer is giving that offer. That meaning for services rendered voluntarily, you have to remember that consideration is not required. If I met with an accident on the road, my ex-student stopped the car and he will help me to come out of that trouble. So that is a voluntary service. He cannot expect any consideration for that. But if I'll give a special work for if I value a thesis, I set some question papers for a university, that consideration will be there, because that university will ask me whether I'm ready to accept that offer, to value that thesis, set question papers, or to give a guest lecture. I will get the consideration because that university has asked me my willingness to accept that. I have accepted that, I will get the consideration. Now, second point is consideration may move from the promisee or any other person. So whoever, sometimes I told you that offer can be specific or general. So if it's a general, if a company is giving an advertisement, anybody can come and accept that offer. So that is either if it's specific, that specific person can accept. If it is general, anybody can accept. So, but even you have to remember, even a stranger to consideration can sue on a contract. So stranger to consideration, he may not be a party to the contract. So this principle is known as doctrine of constructive consideration. There is an important case in this case, Chinnaya versus Ramaya. So here it's a contract between mother and daughter. Mother was giving some maintenance amount to her brother, and because I don't know the reason, that maybe he is not married or he is dependent on her. So when mother in her old age, she has decided she will give the property to her daughter. So that contract between the daughter and mother was on that basis. Whatever mother was giving that maintenance money, even after getting the property from mother as a gift by the daughter will continue to give that. Daughter agreed to the terms and conditions of the mother, but later, once the property has come to the daughter changed that word. That meaning there is no relationship between mother and the brother. I got the property from my mother. Why I have to give it to my maternal uncle? She refused to continue with the payment. So here what happened is the court decided that this agreement between mother and daughter has come with the condition that whatever mother is giving it to the maternal uncle or her brother, so that continue to do, the daughter has the responsibility to do that. With that condition, it has come. So the daughter has got every right, has an obligation to continue to give that maintenance, what the mother used to give it to her brother. So this is known as doctrine of constructive consideration. Even a stranger can challenge that quote in that quote, because the stranger, mother's brother's name was involved or mentioned in the deed on the contract. So he has got every right to get that, whatever is mentioned in the document. Now, third is consideration must not be illusory, but should be real and specific. If I'll tell you that I'll take you to the moon, I will take you to the sun, I will take you to that, anything, imagine, I will discover something by magic. These are all not possible for me to achieve. So I cannot give that as a consideration. But whatever I am giving should be real and specific. I can give some consideration in monetary terms. I can give something in kind. So this is very important. Whatever you can give as a consideration, as a token of your service, that only you can give as a consideration. It can be in monetary terms, it can be in kind also. Kind meaning anything. You are buying a valuable item and giving. So physical or legal impossibility of the thing promised makes it unreal consideration. If you're promising something unreal, it is not a valid consideration. Now, fourth point is consideration need not be adequate. It is not necessary that consideration is the actual market price. It can be less than that, it can be more than that. See, prime properties, usually it will go above the market value. In Mumbai, how they will do that? They will sell at very high rate. So we have to remember that it can be very high also, it can be very 10 times, 20 times, 100 times more than the market value. If they are ready to, if somebody is ready to buy, it is acceptable. If it's less than the market value also, sometimes consideration for 1 rupee, 100 rupees, anything, it's accepted. So court will never interfere on the inadequacy of consideration. Fifth point is consideration must be lawful. Now, lawful meaning whatever is allowed within the country. So, as per Section 23 of the Indian Contract Act 1872, consideration is unlawful if it is forbidden by law during terrorist activities, selling drugs or consuming drugs, alcohol, cigarette, entering underage to a pub. All these are unlawful. So, here, if one act is of such nature that if permitted would defeat the provisions of any law. Say, for example, your check validity is 3 months. Or ordinary debt, the validity is 3 years. You cannot say for one instance, one transaction, I am making the check valid for 4 months. It will not be acceptable by the Reserve Bank of India. The banks will not accept that. We cannot defeat the provisions of Indian law. So, or if it is fraudulent, selling drugs, anti-terrorist activities or terrorist activities or criminal things you are doing or communal violence you are creating, sending unnecessary WhatsApp messages, all these are not allowed in our country. So, or it involves or implies injury to the person or property of another, attacking somebody or attacking somebody's property. So, the court regards it as immoral or opposed to public policy, involving in prostitution, gambling, all this not allowed. Sixth point is consideration may be an act or abstinence or promise. An act, I will do something. I will buy a car. I am entering into a contract that I will pay the consideration. Abstinence, I will not publish the same material with another publisher. Not doing, I'll get consideration. Promise, I will write a book on a future date. Now, the last point is consideration must be past, present, or future. How consideration can be past? Whatever services they have rendered in the past, I am compensating now. So, consideration is past meaning whatever, see, I authored a book 2 years back. Due to COVID, they were not able to pay me royalty. Now they are paying the royalty. It is past consideration. Present consideration, I am writing a book, the publisher is giving me a royalty. That is present consideration. Future consideration, that I am writing a book, or the publisher is telling me that end of the March 31st financial year we will pay you the royalty. That is future consideration. So these are the points I want to explain. The 8 points which are considered as the legal points for considering or consideration to make it a valid point. So consideration is important for a valid contract, and these 8 points are the valid points to make it a valid consideration. So this is what I want to explain. Thank you.